I've been publicly shamed, I'm humiliated, and I am embarrassed.
In October 2009, in Columbus, Jelani Platt's excitement turned into sorrow as her husband, Zyderriou Platt, brought tragedy into their lives. Now, they face a courtroom showdown. Amidst the grief and chaos, the victim's family finds comfort in their determined efforts, standing strong in the midst of the turmoil.
Don't get up now. Calm down. Calm down. Got the taser. We're fixing the taser now. Don't calm down. Fixing the taser. Don't do it. Don't do it. Calm down. Don't do it. Don't do it. Don't do it. Here. You should die. Give me on. Give me on. It's on your back right now. Don't do it. Don't do it. Hold on. Give me the arm now. Calm down.
Jared, I'm married. I want you to calm down right now.
You should die. And you deserve it. My sister. Calm down. Calm down. Sorry. We had to do that. I know. You should die.
Zyderriou Platt was sentenced to 2 consecutive life terms, along with an extra 5 years for a weapon charge. In a shocking twist, former Nashville judge Casey Morland, once a respected figure in the city's judicial system, has been sentenced for his corrupt actions. His crimes, including attempted bribery and embezzlement, have deeply affected the lives of those he was supposed to serve. Let's go to the U.S. District Court in Nashville to uncover the story of Casey Morland, the corrupt judge who has permanently damaged the judiciary's reputation. Casey Morland rose to prominence as a judge in the Davidson County General Sessions Court, known for his authoritative presence and reputation for fairness. He quickly became one of the most influential figures in the city's judicial system. As Morland's power grew, whispers of his questionable conduct circulated. Allegations of granting privileged treatment in exchange for sexual favors started to emerge, tarnishing his once pure reputation. The FBI took notice and launched an investigation to uncover the truth. It was discovered that Morland had attempted to bribe a former lover, hoping to silence her and obstruct the investigation. His actions showed a complete disregard for the law and a willingness to go to extreme lengths to protect his reputation. The evidence against Morland was overwhelming. Phone records, witness testimonies, and financial transactions painted a damning picture of a judge who had betrayed the trust of the people he was meant to serve. The once respected figure was now facing the consequences of his actions. The allegations against Casey Morland are deeply troubling. His actions undermine the judiciary's integrity and destroy public trust in the justice system. As the investigation unfolded, Morland's grip on power began to slip. The weight of the evidence against him became too great to ignore, and the public demanded justice. In 2017, facing mounting pressure and the imminent exposure of his crimes, Morland resigned from his position as a judge. His resignation marked the beginning of the end of Casey Morland's reign of corruption. The federal investigation continued, uncovering even more shocking revelations about his involvement in embezzlement and witness tampering. The evidence against Morland was presented in federal court, where Chief District Judge Waverly Crenshaw presided over the case. In that courtroom, Casey Morland was sentenced to 44 months in prison, a fitting punishment for a man who had abused his power and violated the trust of the community he swore to serve. In addition to the 3.5-year sentence, Morland was also ordered to pay $18,000 in restitution. Next, we will examine the scandalous case of Teresa Brennan, a corrupt judge recently sentenced to life behind bars. Brennan's actions, from perjury to tampering with evidence, have shaken the foundations of justice and left a trail of distrust. It all began with Teresa Brennan, a former judge in Livingston County, Michigan, who was once respected for her position of power and authority. However, her fall from grace was swift and shocking as events unfolded, leading to her eventual sentencing for perjury. In 2017, concerns about Teresa Brennan's conduct were raised by her ex-husband's divorce attorney during their proceedings. Accusations of an affair with a Michigan State Police sergeant and potential tainting of a double homicide case were brought to the attention of the Michigan Judicial Tenure Commission. This marked the beginning of a lengthy investigation into Brennan's actions. Over the nearly 2-year investigation, shocking revelations emerged. Testimony from retired judges, defense attorneys, and assistant prosecutors painted a picture of gross misconduct and abuse of power. It was alleged that Brennan had engaged in an affair with Michigan State Police Sergeant Sean Furlong, who was a witness in a murder trial she presided over. In January 2013, Jerome Kowalski stood trial for the murder of his brother and sister-in-law. Brennan, the judge overseeing the case, had a close friendship with Furlong, which raised concerns about bias and impartiality. The Michigan Judicial Tenure Commission concluded that Brennan had failed to disclose this relationship to the parties involved, denying them the opportunity to request her disqualification. The Tenure Commission's investigation also revealed that Brennan had engaged in other acts of misconduct. She was accused of tampering with evidence in her own divorce case, attempting to remove material from a cell phone that was considered a marital asset. Additionally, Brennan was found to have lied under oath during her divorce deposition, claiming she was joking when she asked her staff to research how to delete information from her phone. In April 2019, the Michigan Judicial Tenure Commission recommended Brennan's removal from the bench, citing her persistent impatience, undignified behavior, and discourtesy towards others. The Michigan Supreme Court agreed with the commission's findings and removed Brennan from her position as a judge in the 53rd District Court. She was also charged with perjury, tampering with evidence, and misconduct in office. The perjury charge carried a potential sentence of up to 15 years in prison. However, in December 2019, Brennan pleaded guilty to the perjury charge as part of a plea deal with the Michigan Attorney General's office, which set the maximum sentence at 6 months in jail. The sentencing hearing took place in January 2020, with Circuit Court Judge Paul Cusick presiding over the case. During the hearing, Brennan tearfully expressed her remorse and shame for her actions. She acknowledged the devastating consequences of her behavior, including the loss of her career and the stigma of being labeled a felon.
I've suffered because of my actions. I hate that I put them through this. I've been publicly shamed, I'm humiliated, and I am embarrassed.
In the end, Judge Cusick sentenced Brennan to 6 months in jail, along with 200 hours of community service and 18 months of probation.
6 months in the county jail, followed by 18 months probation.
For our next case, we head to a Monroe County courtroom in Michigan, where the case of Jared Williams, a corrupt judge whose actions sent shockwaves through the legal system, is being presided upon. It all began with a Michigan State Police investigation revealing a web of treachery and corruption surrounding Judge Jared Williams. The investigation revealed that Williams had been involved in a disgusting world of prostitution, hiring and transporting women for his own personal gain. The charges against Williams were nothing short of shocking. He was accused of 4 counts of hiring women for the purpose of prostitution and 1 count of transporting a person for the purpose of prostitution. The evidence presented during the trial painted a disturbing picture of a man who had abused his position of power for his own twisted desires. According to the victims' testimonies, Williams used various online platforms under the alias of Michael Collins to find his victims. He lured these unsuspecting women into his web of manipulation, promising them a better life and financial security on his profile.
His profile advertised as saying, "Are you looking for a sugar daddy? Searching for younger women to be a sugar baby."
But what these women didn't know was that they were stepping into a nightmare. Once under Williams's control, they were subjected to unimaginable acts of torture. Their lives were forever scarred by the trauma they endured at the hands of this corrupt judge. As the trial unfolded, the courtroom was filled with graphic statements from the victims, recounting the horrors they had experienced.
Bag to my parents' balcony, and he tied my hands so I couldn't get out of the chair I was in. I was suspended on the chair with my hands tied so I couldn't move at all.
Williams, in a desperate attempt to explain his actions, offered a lengthy statement in court. He claimed to have been in a dark place during the events, but his words fell on deaf ears. The damage had been done, and the victim's pain could not be erased. Ultimately, the jury found Jared Williams guilty on all charges. The former judge, once entrusted with upholding the law, was now facing the consequences of his heinous actions. The judge sentenced him to 1 to 5 years in prison for the charges brought against him. It was a moment of justice for the victims, a small step towards healing their wounds. Because this lady tried to lie to the judge, she quickly went from happy and smiley to shocked and worried.
You or coerce you in any way for you to enter into a plea?
No.
All right, counsel, you can please pardon your client.
Yes, I'd like to direct your attention to June 15th, 2023 and June 22nd, 2003. Did you fail to appear for a probationary instruction?
Yes.
And additionally, while on probation, you did accrue a new charge, correct?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea to the probation violations. Enter a plea of guilty based upon your enter a probation violation based upon your plea of guilty, and that would be technical violations 1, 2, 3, 4, and 5. And counsel?
Your Honor, I saw the recommendation for 60 days jail. I asked that my client get credit for the time that she's been in since December 1st. I'd ask that it run concurrent with the admonishment that she's received from the charge that she just took a plea on. And then furthermore, she did ask that during this time in custody, if possible, she would like the opportunity to be tethered to treatment. Thank you, Judge.
All right, Ms. Bulchak, did you request to be tethered to treatment while you've been on bond?
Yes, just to try to have time. I mean, I don't think I personally need treatment, but I know that that was something that I asked for when I first got arrested. So I'll do the days, I'll do whatever it takes, but I really just want to get home.
Okay, ma'am, let me ask you a couple questions. Number one, if you don't think you need treatment, why did you ask to go to treatment?
I was trying to have like the days made up. I don't know if it, I don't really know. Because
Well, ma'am, you asked for treatment, so why did you ask for treatment?
get out of jail,
I'm sorry?
to not have jail time.
Oh, that's what I thought. Okay, so, and you don't think you need treatment? Given what's been going on with you the last year, you don't think you need treatment?
Honestly, no. I really found myself in here. I've been spending time with myself. I don't know. I don't feel like I need a guy or anything. I don't know. I just want to get going on life.
Well, man, the way you've been going on life, not a great start. How old are you?
25.
25. And now you have 3 drug-related convictions. 3. Your under advisement status is revoked. You had an opportunity to not have your possession charge on your record, and you didn't do a darn thing with probation. Not at all. You just ghosted us.
I know. If I get probation this time, I told myself, like, you know, it would be at least 6 months. That's all I would really need to get like clean, and you know, by summertime I'd be, you know, working. I really want to get a car. But aside from the job thing, just, you know, I want to draw and make music, and I don't know. I just want to do things for myself, and I like coffee again. I don't know, just things I've been drinking a lot of water. There's just a lot of things I wasn't doing before that, like, I've been doing since I've been in here. So I haven't been.
Ma'am, part of the concern, right, is when you get out, how are you going to continue to do stuff, right? That's part of what treatment is, and you don't think you need treatment. So
I've been to treatment 7 times. I've been to treatment like 7 times. I don't know. I know how to work the program. I know to go to a meeting when I need to. I know there's just different times.
Through the motions. So you just go through the motions, you don't really receive what it is that you're getting.
I really think I've learned a different way. I've been incarcerated this time, ma'am. I don't know. It feels different. It feels really different. I'm willing to go any probation that you need me to, but,
Judge, we're ready to hear the sentencing. We are ready to proceed, Judge.
Okay.
Yes, no, man, you're not getting probation, I can tell you that much. The court's going to, on 23405, the court's going to adopt the recommendation, revoke probation, close the case without improvement, $50 probation violation fee, 60 days jail. On 23739, the court's going to adopt the recommendation. Your under advisement status is revoked, your probation is revoked, $50 probation violation fee, 60 days jail. The court will know that will be served concurrent. And then the court's going to also order on 232479, the court's going to order 93 days jail. Credit for your 15 days. That's consecutive with 23739 and 23405. And the court will suspend your fines and costs on this matter.
What?
Any questions, counsel?
No, Your Honor.
Any questions, ma'am?
So, how many days?
Well, 60 on your probation violations plus 93, plus 15. So that's going to be, I can tell you exactly what that is, ma'am.
They only been walking. I'm telling you.
Is there any way I could do treatment?
138 days.
Is there any way I could do treatment?
And you told this court you don't need treatment.
Okay,
No, you told this court, the only reason you said that is because you didn't want to do the jail time.
no, that's
So
not,
you can do the jail time.
ma'am, I'll do treatment.
And quite frankly, ma'am, with your lengthy warrant status and you're absconding from probation, I'm not sure that you would not abscond from your treatment provider.
Ma'am, I can't do 130 days.
Yeah, you said you didn't need treatment.
I do.
The problem was, when I went to sheriff, I got the people over.
I need help with housing when I get out of here. I'm gonna need.
I'm sorry?
I need help with housing when I leave here. You know, I have my.
Okay, I need that talking in the background to please stop.
Somebody in.
My court recorders indicated our record is a mess because of all the talking in the background. And what was that, Ms. Bulchak?
I really don't. I think I need treatment instead.
Ma'am, you were very clear. You've been to treatment 7 times and you don't need treatment anymore.
No, I do.
You know how to work the program.
No, I got a little ahead of myself. That's what I asked for when I first came in, because I do have a drug.
Judge, potentially, Judge, I know that potentially she might be asking for some sort of mental health treatment, but I understand this docket does need to be moved along. So if necessary, we have to have the matter recalled later in the morning to potentially have it reevaluated. But I understand the docket does need to move along, Your Honor. Thank you, Judge.
Thank you. Ms. Bulchak, I'm not ordering treatment for you at this point because you stated that you don't need treatment and you only asked for it so that you didn't have to do jail time. Given that and the fact that you had absconded from probation with this court, the court is concerned that you're not going to abscond from treatment. So at this point, 138 days is what you're going to serve, ma'am. And we're all done. Thank you. Off the record. Have a good day.
On July 5th, 2023, in Arizona, Melody Felicano Johnson prepared coffee for her husband, Robbie Johnson. Did Robbie's coffee have a honey-like taste because his wife poisoned it out of sheer hatred? As the saying goes, the poison from a lover's hand is rumored to taste like honey. Assuming a wife who doesn't value her husband's life will readily forgive him is misguided.
All right, thank you. And for the defendant?
Your Honor, 3 things need to be said at the outset of this sentencing. The first, and I need to make this very clear, is that we are no longer here on attempted homicide or attempted aggravated assault charges. And I say that because there has been so much attention on this case and it's still being reported inaccurately. Melody Johnson has pled guilty to 2 Class 6 offenses which occurred here in Pima County on July 11th and July 18th of last year. And I believe that that should be the court's focus. For several months, the state perpetuated a narrative claiming Robbie Johnson was given a lethal dose of, and I have that written here in quotes in my notes. This was false based on a number of things that were true both now and when this case was indicted. And that's why I supplied you with the poison control call as well as our chemist's report. I want to thank Mrs. Otto, however, for her work on this case. It should be made clear that Mrs. Otto was later assigned this case and spent many weeks trying to quickly get up to speed, and she really went above and beyond while handling numerous other cases. We are asking the court to consider a time-served sentence. Melody Johnson has been in custody for nearly a year with no meaningful opportunity for release. She has been held on a $250,000 bond. I can't even afford that. Not that that's a shock to anyone. We also welcome probation, but we do not believe that more time incarcerated is appropriate. Melody Johnson has accepted responsibility for her actions in this matter. She has, as indicated by the pre-sentence report, apologized to the victim, Robbie Johnson. She makes no excuse for her conduct, and that was in her letter to the court. She has also apologized to her friends and her family because they have also been greatly affected by this, given the nature of the attention around this case. Mrs. Johnson has received formal diagnoses for anxiety and depression, and it is true what Mrs. Otto has said. She has long struggled with her mental health. She currently feels stable and has been taking medications while in custody. She intends to continue treatment upon release. And I mention this because I do believe that Mrs. Johnson is capable of seeking support without assistance, in part evidenced by her low risk assessment in the pre-sentence report conducted by probation. Mrs. Johnson was born and raised in the Philippines. She's the eldest of 8 children. As I mentioned in my memorandum, her father worked in law enforcement and was a disciplinarian. Mrs. Johnson will later come to learn that appropriate disciplinary actions varied culturally. Throughout her interview with probation, she remarked that harsh punishments were normal when she was growing up, and that much of what she experienced likely would have crossed the line here in the United States. Still, Mrs. Johnson maintains that she suffered no abuse at the hands of her family growing up. She actually remains close with her family and is close with several family members. She speaks with her mother and sister daily. The two support her both emotionally and financially. Something that occurred while Mrs. Johnson was incarcerated is that her father passed away, and this was incredibly painful and difficult for Mrs. Johnson. Her father, given the nature of his work, was absent for much of her life. So for her to not be present for his funeral and those proceedings was really quite painful for her. She was a very anxious and fearful child. She has 2 children of her own, as you heard already. Nathaniel was mentioned. Stephanie is her other child. She cares for both of them very deeply. She would never harm them. Friends and family have described Mrs. Johnson as loving, sweet, compassionate, and hardworking. She's also a woman of faith. She's known to be dependable and family-oriented. The offenses before the court appeared completely out of character for those that knew her best. Mrs. Johnson does not abuse alcohol, but she does acknowledge her mental health problems and should be seen as amenable to treatment and an excellent candidate for rehabilitation. She's been proactive in understanding her mental health and has completed anger management programming, as you saw, as well as educational courses on courtroom etiquette and parenting while incarcerated. She has demonstrated a desire to better understand her circumstances and to learn from them. Mrs. Johnson has a stable residence if she is released with friends who will take her in. That has been verified.
No matter how hard a criminal tries to defend themselves, if there is enough evidence, it is impossible to escape court without consequences.
And are you on probation or parole right now? No. And it looks to me like on the second to last page of the plea agreement, there's a line with your name on it and the signature. Did you sign this plea? Yes. And did you read it before you signed it? Yes. And do you feel like you've had enough time going over it with your attorney and you feel comfortable that you understand its contents? Right. Now, if you take the plea, Ms. Johnson, you are giving up certain constitutional rights. Those constitutional rights include keeping your plea of not guilty and having a trial by jury. If we have that trial by jury, your attorney would continue to represent you at little or no cost to you. And at the trial, you would be able to confront and cross-examine the witnesses that the state calls against you. And you could call your own witnesses and have them ordered to appear by way of subpoena if you decided that was appropriate. You'd also have the right to testify at that trial or not. It would be up to you. You could keep your right to remain silent. And you'd be presumed innocent until proven guilty by beyond a reasonable doubt. Do you understand all that? Yes, ma'am. And obviously, if you plead guilty, we're not going to have the trial because in a minute, I'll ask you to plead. You don't have to tell me what you did, okay? There's also, in this plea agreement, you're giving up your right to have a jury trial on aggravating factors. And what that means is basically, if the court did want to send you to prison and send you to prison for more than a year, the court can't do that unless there's some kind of finding of an aggravating factor. And you have the right to have the jury find those factors. But under this plea agreement, you're waiving that right and letting the court decide what the aggravating factors are on its own. Do you understand that? Yes. And finally, by entering a plea agreement, you would give up your right to direct appeal, and your only avenue of relief would be to file a petition for post-conviction relief with the judge that sentences you. Do you understand that? Having heard about all of your rights, are you willing to waive your rights and plead guilty today? Yes. Do you understand your rights? Yes. All right, so let's talk about the two charges. They're amended count 1 and amended count 2, both adding harmful substance to food or drink, a class 6 designated felony. Let's start with amended count 2. It indicates that on or about July 11, that you intended to harm, is it Robbie Johnson, by adding or mingling chemical compound to water, food, or drink. How do you plead, guilty or not guilty? Guilty. Right. Then amended count 3, is at the same count, and this alleges that on July 18th of 2023, you intended to harm Robbie Johnson by introducing, adding, or mingling a compound to his water, food, drink, or medicine. How do you plead guilty or not guilty? Guilty. How do you want to do the factual basis? Does counsel want to do it, or do you want me to ask Ms. Johnson?
I can do it. That's
Sure,
fine.
go ahead.
Sure. As to amended count 2 on July 11th, Melody intended to harm Robbie by introducing a trace amount of bleach, which is a chemical compound, into the water reservoir of his coffee maker, which Robbie then later intended to drink. And that happened here in Pima County, excuse me. And as to count 3, the same thing happened on July 18th.
Ms. Johnson, you just heard what your attorney told you. Are those things true? Yes, ma'am. So you did those things? Is that yes? Yes, ma'am. Okay. State satisfied with factual basis? Yes. The court finds that the plea is knowingly, intelligently, and voluntarily made. A factual basis exists for it. The plea is accepted and entered of record. Is 30 days okay for sentencing? Yes, sir.
Your Honor, that should work for me. And I spoke with Mrs. Otto. I do not believe that we can appear in the Division BE in 30 days, given the changes. We have stipulated to a sentencing in front of Judge Sean Memphis. Is that true?
Yes, sir. All right. Does he know that? Is he okay with it?
He does not know that, but we'll verify before the sentencing actually occurs.
All right.
Regardless of the crime committed, all offenses are subject to legal punishment, with judges delivering sentences in accordance with the law.
This time the court enters the following findings. The court finds an aggravation. There was emotional harm to the victim. The court finds a mitigation. The defendant accepts responsibility. She expressed remorse in her letter to counsel. These are his first felony. The victim recommends probation and mental health treatment rather than punishment with more jail and or prison, which the court takes into account. Defendant appears rehabilitatable and amenable to probation. Given all that's before me, it will be the sentence of the court that she be placed on 3 years of probation, the terms to be concurrent with each other, to begin on today's date, May 10th, 2024, subject to standard conditions of probation, including that you report to probation within, and because it's the weekend, I'm going to give her till Monday at noon.
Great.
But any law enforcement contact is to be reported within 48 hours. She does not have any contact with the victim in any form unless it's approved in writing by probation. What is the status of is there a divorce case pending?
There is.
Or they would have to have contact?
They are both represented by attorneys.
Right, so we'll just show they're not to have contact, or she's not to have contact with him unless it's in a legal context.
Sure.
She's to participate in mental health evaluation and follow any recommended treatment. And just the court will order that she not consume or possess any substance containing alcohol. The following fines apply: time payment fee of $20, probation fees of $65. Court will reduce attorney's fees to $25, probation assessment of $20, a crime penalty assessment of $13, victim right enforcement assessment of $2, victim rights fund assessment of $9, and indigent administration assessment of $25. Ms. Johnson, you do have the right to petition the court for post-conviction relief. You must do that within 90 days of today's date. You also have the right to move to set aside the convictions if and when they qualify under Arizona law. If you complete probation or receive an absolute discharge from prison, and if you've not been previously convicted of a felony and have paid all or restitution, your civil rights will automatically be restored. If you have been convicted of a felony in this or another state and have not paid all or restitution, you could still apply to have your civil rights restored. This does not apply to the restoration of right to possess firearms if you're convicted of a serious or a dangerous offense. Pursuant to ARS Section 13911, you may be eligible to have this conviction and associated legal records in the case sealed. Defendants to be released on probation upon processing. Make sure that you notify probation as to where you're going to live and that you follow all the conditions of probation. Thank you. Parties are excused upon signing of the probation conditions.
Thank you, Your Honor. On October 23, 2013, in Deltona, Luis Toledo's brutality knew no bounds as he mercilessly took the lives of his wife, setting a horrific example. Every 911 call for an emergency signals the start of another dark chapter.
I'm sorry, I can't hear you because they're having confrontation in front of me now.
Okay, give me 1 second, okay? Let me dispatch the call, okay?
All right, I appreciate it.
Stay on the line, okay?
Stay on the line, you said?
Yeah.
Okay.
No, and it's wrong. And it's wrong. And both of y'all deserve each other, man. That's all I'm saying.
I
just wanted your job to know how you go ahead and go company treats me the whole round over. That's not true, man. Yes, it is true. And I got some messages to show you, Bobby. I got some messages to show you.
I'm sorry.
If it was true, it'd be something different, but you know, I'm not upset about this guy coming here. I'm upset with you telling him that.
Okay.
Yes.
Give me 1 second.
Okay.
Multiple units, Charlie 23, copy your right.
Oh.
1323. Are there any involved, ma'am?
No, not at all.
Okay.
Though a lost loved one can't be recovered, justice offers some relief to the grieving family. However, the journey from the culprit's arrest to finding relief is anything but smooth.
Just want to make sure that
Some cases are so inhumane that upon hearing them, we question our own humanity.
28-year-old mother of two at the time of her murder. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had a bright future. She was a vibrant young woman. She had many friends, she had a large family, and she had After her children were born, Zyderriou, or Jessie, as her mother called her, returned to school. She wanted a better life for her children. A student at Rollins College, she was making good grades and working on her last credits for graduation. Jessie didn't have much spare time. In fact, if she ever got a Saturday without rules or without children, she wouldn't know what to do with it. You see, in addition to her academic work, Jessie had a full-time job in the HR department at American K-9. AM K-9, as it's better known, is a civilian contractor in charge of training and deploying K-9 officers for law enforcement agencies, for the military, and for paramilitary organizations. These trained dogs are invaluable resources in the line of duty. And in her line of employment, Jessie worked closely with the handlers that arranged for our K-9 partners to be deployed all over the world. When she wasn't in school or working, Zyderriou Suarez spent time with her family and friends. She had 2 young children, Michael Elijah Otto and Talia Otto. The 2 children were the product of a previous marriage. You'll hear during this trial that they were born between the marriage of Zyderriou Suarez and Michael Otto. The young boy shares his father's name. Throughout the course of the trial, you'll occasionally hear Michael's name, and I don't want you to be confused. Though he may appear and testify in this trial, it won't be until the penalty phase, if we get there. The 2 children were what's sometimes called Irish twins, meaning that they were born in the same calendar year. And roughly 10 months apart, they were as close as 2 children can be. They were great friends, and they had all the activity and curiosity that you would expect for 2 children of that age. They did well in school, they participated in youth activities, and they maintained a close relationship with family and friends. During the course of this trial, you'll likely hear how Zyderriou Suarez and her children came to know the defendant. You'll hear that their relationship started about 4 years prior to, and that the 2 were married soon after that they met. You'll hear that Zyderriou's mother, Felicita Perez, and Zyderriou's best friend, Sabrina Newell, another witness in this case, neither one of them particularly liked the defendant. There may have been a time that both thought he was good for the children, but they maintained that he was a bad match for Jessie. Rather than destroy the relationship with a young woman in love, the 2 stood silent and allowed this marriage to take place. Over the years, there were up and downs. As many young families, they struggled with finances, but they ultimately had enough money to raise the children and acquire several large ticket items. You'll hear the evidence in this case shows that the defendant was occasionally out of work and that he took primary responsibility for the care of the children while Jessie kept them afloat. With her income, they were able to finance a home and her new Honda Accord, a vehicle that will be mentioned frequently in this case. They were only married 2 years, just a little less actually. And as the years rolled by, the defendant tried to make more of himself. He had recently enrolled in barber college, and though he was advancing toward a career, his slow start and inability to earn significant money was a source of tension and often the subject of fights. Similarly, the manner in which he cared for her children frequently was part of the dispute. Though the children were always healthy and happy, Zyderriou Suarez had high hopes for her children. She wanted their grades to be perfect.
As the shock of an event fades, the weight of grief often grows heavier over time.
At the time of that conversation, did you know that your daughter had asked him for a divorce?
Yes.
How did the conversation at your home end?
With my daughter? After he left.
Well, I'm sorry. How did the conversation between the 2 of them?
Or them?
Yes, ma'am.
Well, all of a sudden I went to the kitchen, and then when I came back, because the conversation was in the garage, and then all of a sudden Jessie come in, And I said, did he leave? But then he wanted a water or something. He came back in. We were eating. And I offered him food anyway. And I gave it to him and then he left. But Jesse has said they came in an agreement.
I think you testified a moment ago, but I want to make sure. What time did Mr. Toledo leave your house that night?
Around 7.
Did your daughter immediately leave the house?
No.
And how long did she stay at your house?
Around 8, she left the house. She took a shower, we ate, and then it was around 8 when she left.
Did you try to get her to stay at your house?
Yes.
Did she ultimately leave?
Is that it?
Did she ultimately leave your house?
Yeah, she wanted to sleep on her bed.
You said she wanted to sleep in her bed?
She wanted to sleep on her bed, she said to me.
Is that the last time you ever saw your daughter?
Yes.
Is that the last time you ever talked to your daughter?
Yes.
Is that the last time you saw your grandchildren?
Yes.
Did you ever talk to them again after that?
No.
Have you, relationship with your daughter, have you developed a practice of talking to her every day?
Yes.
Tell us how those conversations occurred and when they occurred.
Every morning when my daughter used to go to school, take the kid to school, she used to call me. At her lunch, she used to call me. My daughter used to call me for any little thing. She used to call me.
But you spoke with her every morning. That was the practice.
Yes.
And what time did that call usually take place?
What time?
What time did the call usually take place?
Around 7:38, 7:38, around that time.
What time did you typically leave for work?
5 in the morning.
Still dark out?
Yes.
As you left the subdivision where you lived, did you pass their house?
Yes, front and back.
Did you pass their house on October 23rd, 2013?
Yes.
Do you have any particular feelings as you passed the house that day?
No.
Sustained.
When you passed the house, did you look at the house?
Yes, like I always used to do.
What did you notice about the outside of the house?
In the front, everything was the same, but on the back, the light was on.
Was that odd to you?
Yeah, because they usually didn't leave it on.
Other than that, nothing stood out?
No.
Normal morning?
Yes.
When was the first time that you became alarmed that something was different?
Because my daughter didn't call me. And
did she have any reason to run away from home or to cut ties with you and your family?
no, not at all.
Did the children have any reason to run away from home or cut ties with you and your family?
No.
Did they miss major events in their own lives and the life of your family as well?
Yes.
Birthdays,
Yes.
holidays,
Birthday, holidays.
graduation, funerals?
Yes.
How long did the search effort last for them or for their with law enforcement?
I was saying for a month, but they had never stopped either. Everybody's still looking.
Is it fair to say that this was a high-profile search effort?
Yes.
Is that something that your daughter would have responded to if she was alive?
Of course, yes.
You think that she would have reached out to you to ease your pain?
Yes.
Extracting words from the accused in the interrogation room is similar to finding a needle in a haystack. Yet, interrogators possess the art of extracting secrets.
How old are you now?
Huh?
How old are you now?
I'll be 32 in December.
32? Okay. December. My name is Investigator Pat Yard. Okay, I work for the Volusia County Sheriff's Office. And I want to talk to you today about some missing people, okay? The our case number for it, it's 13-29517. From what I know of you, you're Louis Toledo?
Correct.
Okay. And I had your date of birth as December 19th? Okay, of 1981?
Correct.
All right. Do you live at the house, 317 Covenant Gardens?
Yes, sir.
Okay, that's in Deltona. And what's your phone number? I guess I want to lay it out there and tell you this, that this is a totally voluntary type thing for you, okay? I'm not going to talk anything about what happened in Seminole County. I have nothing to do with that. This is strictly a missing persons investigation. If you don't want to talk to me, you're free to go. I will take you back to the jail, and then the process will begin wherever Seminole County has on you. I want to talk to you. I need your help on this case, okay? Your wife is missing, and the 2 children are missing. Are they your children or her children?
They're my kids, because I raised them, but not biologically.
Okay.
I consider them my kids.
How long have you and your wife been together?
Almost 5 years.
5 years, okay. And you've lived in Deltona the whole time?
No. We first moved in together in Maitland. Excuse me. We first moved together in Maitland back in, I think, 09.
Okay.
And then we moved down to, excuse me, we moved down to the townhome. And right before the Trayvon shooting, we moved out of the townhome.
Wow.
And we bought the house. We got married in 2011.
Okay.
January 1st, 11.
Wow, that's pretty cool.
Yeah. And we have a house, and we've been there since.
Okay.
We kept the kids at Bentley Elementary because the townhome is still under her. It belongs to her uncle.
Okay.
So we kept them there because A+ schools in Volusia County. Some Volusia County schools are not that good.
Okay.
As far as the elementary schools, we're going right now.
Okay.
And the kids loved it there. And that was it. We've been there since.
Okay. So the kids still go to Bentley?
Yes, correct.
And that's in Seminole County?
Yes.
Okay. I'm not real familiar with. Is it in Lake Mary?
No, it's across the street from the apartments, from the townhomes.
Okay.
It's where Kohl's is.
Is it Seminole Town Mall area?
Yes.
Okay.
Yeah, it's like right behind Kohl's. It's right across the street from Derby Park.
Okay. Now, I have the spelling of your wife's name. Her first name is
Yesenia.
Yesenia?
Yesenia.
Enia. Middle name was
Yvette. Ivette.
Okay, and then Suarez?
Suarez.
Okay. But your last name is different, but you guys are married.
Yes,
how does that work?
Because we haven't changed it over because of the school.
Mm-hmm.
We didn't want to have to go through the whole, FAFSA thing and all of that. So we just left it how it was until she finished school, and then we switched the name when we had a chance.
Oh, okay, that makes sense.
It didn't mean anything to have the name changed over fast.
Okay. The 2 children I have, is it Michael?
Michael, Michael, and the middle name is Elijah, and
okay.
His last name is Otto.
OTTO? Okay, let me just make sure, because what we did is we put out a teletype, because again, we don't know where they are, so we want to make sure that anyone who comes across them obviously gets in touch with us. So we went over the spelling of your wife's name, her date of birth. Do you know it off the top of your head?
Yes.
What's that?
It is 8/17/85.
Okay. And then we talked about Michael Otto.
It's 8/19/05.
Okay. And then his sister is
Dahlia Otto.
Dahlia Otto?
Yes.
Okay.
She has the same middle name as her mother.
Oh, okay. And her date of birth, do you know that?
Yes, it is October 8th, 2004.
Okay. All right, just making sure we had that correct, because again, I don't want to put bad information out, so it's obviously very paramount that we're putting out the right stuff. So I do appreciate you verifying that stuff for us.
The judge decides the punishment by considering all witness evidence and the severity of the crime, following the law.
Now, Mr. Toledo, you watched the same trial I did. We both saw the same evidence, which was presented to the jury. Your version of what happened here was soundly and wisely rejected by the jury. In your own mind, you convinced yourself that your wife deserved it. That's just plainly wrong. That someone else killed Michael and Toledo. You told the police as much. That was a lie that only you believe. You told the police that someone else disposed of the bodies. That too is a lie that only you believe. No one else does. No decent human being could stand idles. You're not a stupid person, you're very smart. You're very wise to the legal system, you're very wise to police tactics. I remain convinced that your decision to kill your wife was made the moment you shut your phone off. You knew what you were doing. In the jury's verdict, there was one very telling answer. The jurors were asked that if you were remorseful about this, by a vote of 12-0. They said no. Not even the two people who voted to spare your life found any remorse in your actions or your statements. I totally concur with their findings. I don't believe you're remorseful. And as such, you will receive no mercy from the court. Therefore, it is the judgment of the court that for the death of Michael Otto, I hereby sentence you to life in prison without the possibility of parole. For the death of Toledo Otto, I hereby sentence you to life in prison without the possibility of parole. The sentence is to run consecutive to all other counts. For the death of Yesenia Suarez, I hereby sentence you to life in prison without the possibility of parole. The sentence is consecutive to counts 1 and 2. For tampering with evidence, I hereby sentence you to 5 years in state prison, and that sentence is consecutive to counts 1, 2, and 3. You shall receive 1,465 days credit for the time that you have already served, and you have 30 days to appeal the judgment of the court.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.